What rights do temporary workers have in the U.S.? Imagine this. You've just been hired through a staffing agency to work at a warehouse. The contract says temporary, maybe 3 months, maybe 6. You're doing the same work as full-time employees, lifting boxes, running machines, following orders. But you're wondering, do I actually have the same rights as permanent workers? Or am I treated differently because I'm temporary? This is a real question for millions of Americans. Temporary work is common in warehouses, construction, hospitality, and offices. Some workers see it as a bridge to permanent jobs. Others rely on it as their main income. But when it comes to wages, safety, discrimination, and benefits, confusion is everywhere. In this video, we'll break it down. What rights temporary workers have under federal law, what staffing agencies and host employers must provide, how state laws add extra protection, and what you can do if your rights are violated. The core principle: employees versus contractors. The first thing to know is that temporary workers are not the same as independent contractors. If you are hired through a staffing agency, you are considered an employee, usually of the agency, sometimes jointly with the client company. That distinction matters because employees are protected by most workplace laws. Example: a temp hired to work at a factory through a staffing agency must be paid at least minimum wage and overtime under the FLSA. An independent contractor doing the same job might not have those protections. Wages and hours. The FLSA applies the Fair Labor Standards Act, FLSA, and requires all covered employees, including temporary workers, to receive at least the federal minimum wage of $7.25 per hour and overtime pay at time and a half for hours worked beyond 40 in a week. Staffing agencies and host employers can be considered joint employers. That means both can be responsible if wages are unpaid. Example: a temporary warehouse worker in Illinois works 50 hours a week. The staffing agency must pay overtime, even if the host company told them to limit hours. If neither pays, both can be held liable. Workplace safety. OSHA. Protections. Temporary workers have the same safety rights as permanent staff under the Occupational Safety and Health Act, OSHA. Both the staffing agency and host employer share responsibility for providing safe working conditions. Staffing agencies must ensure workers receive basic training. Host employers must provide site-specific training and safe equipment. Workers have the right to report unsafe conditions without retaliation. Example: a temp is assigned to operate a forklift without proper training and gets injured. Both the staffing agency and host employer could face OSHA penalties. Anti-discrimination laws apply equally. Temporary workers are covered by federal anti-discrimination laws, including Title VII. Protects against discrimination based on race, color, religion, sex, or national origin. ADA. Protects workers with disabilities and requires reasonable accommodations. ADEA. Protects workers 40 and older from age discrimination. The staffing agency and host employer are both considered employers for legal purposes. Example: a temporary worker is denied a promotion opportunity at a host company because of race. Both the staffing agency and host employer can be held liable under Title VII. Benefits. More limited, but not always zero. Here's where things differ. Federal law does not require staffing agencies or host employers to provide benefits like health insurance, paid vacation, or retirement plans to temporary workers. However, some staffing agencies offer health coverage to comply with the Affordable Care Act if employees work 30-plus hours per week. Paid sick leave may be available if state or local laws mandate it, for example in California, New York, or Massachusetts. Temporary workers may qualify for unemployment insurance if laid off, depending on state law. Example: a temp working full-time hours for 6 months in New Jersey may be eligible for unemployment benefits once the assignment ends. Family and Medical Leave Act, FMLA. The FMLA provides up to 12 weeks of unpaid job-protected leave, but eligibility requires working at least 12 months for the same employer with 1,250 hours logged. Most temporary workers don't meet these thresholds, so FMLA rarely applies. Example: a temp working 3 months at a staffing agency assignment who becomes pregnant cannot claim FMLA leave unless she meets the hour and tenure requirements. The role of state laws. Some states give stronger protections to temporary workers. California requires equal pay for equal work regardless of job title. Temps must receive at least the same minimum wage and rest breaks as permanent employees. Massachusetts has strict rules requiring staffing agencies to provide written notices about pay rates, hours, and worksite conditions. South New Jersey recently passed a Temporary Workers' Bill of Rights requiring staffing agencies to provide detailed pay disclosures and prohibiting retaliation. Illinois requires agencies to register and comply with worker protection laws. Example: in New Jersey, a temp must be given written notice of their pay rate, schedule, and rights. Failure to do so can trigger penalties against the agency. Retaliation protections. Temporary workers are protected against retaliation just like permanent employees. You cannot be demoted, reassigned, or terminated for reporting discrimination or harassment, complaining about unpaid wages or overtime, reporting unsafe conditions to OSHA, engaging in union activity protected by the NLRA. Example: a temp reports sexual harassment at a warehouse. The staffing agency removes her from the assignment. That may count as unlawful retaliation under Title VII. Union rights, the NLRA, applies. Temporary workers can unionize or join existing unions under the National Labor Relations Act, NLRA. In some cases, they can even bargain alongside permanent employees if they share a community of interest. Example: temps at a manufacturing plant join with permanent employees to demand higher pay. The NLRB recognizes their right to organize together. Real-world cases. Case 1, New Jersey. A staffing agency failed to pay temps overtime. The state fined the agency and ordered back pay. Case 2, California. Temps at a food processing plant injured by unsafe machinery won damages because the host employer failed to provide training. Case 3, Illinois. A temp fired after filing a discrimination complaint was reinstated after the EEOC found retaliation. In Case 4, Massachusetts. A staffing agency penalized for failing to give written notice of pay rates under the state's temp worker law. These cases show that temporary workers have real legal protections, but enforcing them often requires speaking up. Practical steps for temporary workers. 1. Know your employer. You may be employed by both the staffing agency and the host company. 2. Track hours and pay. Make sure overtime and minimum wage laws are followed. 3. Request training. Under OSHA, you are entitled to proper safety instruction. 4. Check state laws. Some states give temps extra rights. Learn them. 5. Report violations. You can file complaints with the Department of Labor, OSHA, or state agencies. 6. Keep documentation. Contracts, pay stubs, and emails are evidence if problems arise. Example: a temp in California denied rest breaks documents the issue and files a claim with the State Labor Commissioner, winning penalty pay, the human side of temporary work. Temporary work can provide flexibility and opportunities, but it often comes with insecurity. Many temps fear speaking up because assignments can end suddenly. Yet, the law recognizes that they deserve the same core protections as permanent staff when it comes to wages, safety, and dignity. Example: a mother working a temporary job through an agency uses those wages to support her family. Denying her breaks or overtime doesn't just harm her, it undermines her household stability. The bigger picture. Temporary workers highlight the gap between traditional full-time employment and modern labor markets. While federal law covers basics like minimum wage and safety, benefits and stability often lag. States like New Jersey and California are leading with stronger protections, but coverage remains uneven. Knowing your rights is the first step to ensuring fair treatment, whether you're at a job for 3 months or 3 years. So, what rights do temporary workers have in the U.S.? More than many people realize, temps are covered by the FLSA for minimum wage and overtime, by OSHA for safety, and by Title VII, ADA, and ADEA for anti-discrimination. Both staffing agencies and host employers share responsibility. States like California, Massachusetts, and New Jersey add even stronger rules, including pay transparency and penalties for violations. The bottom line: temporary doesn't mean disposable. Temps may not always get the same benefits, but they have core legal rights that protect their wages, safety, and dignity. If this video helped clarify your rights, share it with coworkers. Every worker, permanent or temporary, deserves to know the law is on their side.